Guidelines have been released in reference to the ATF arm brace rule as it applies to others. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And let's talk about this. This is a continuing saga in reference to the ATF's release of the arm brace rule. There was a lot of conjecture as to what would happen to specific weapons, and specifically to the state of Connecticut, where we have the other platform. I had done a video on that a while back, and now we're starting to come to fruition to find out what exactly is going on. But as of yesterday, on February 8th, the Department of Special Licensing and Firearms released a memo on their guides, or their guidelines, to how they interpret what the ATF is doing in reference to state law. Now, they make it clear right from the beginning that this does not constitute legal advice, which basically means, yeah, we're not going to take any responsibility for anything we're saying in here, but this is what we think. And I've read this 3 times. It's not that long, it's 3 pages. I've read it 3 times, and I'm getting a lot of the same feeling that I got when the ATF did their webinar on February 1st. A lot of what they said was, yeah, refer to state law. We're not sure. State of Connecticut in some regards is doing the same thing when it comes to this document. But I am going to talk about this document. Okay. I'm going to pull it up here. Oh, nice and fancy. Okay. I'm just going to go right to... Now, I've been looking for this document. I'm going to try to get it into the description box so you can read it if you wish. But I am going to go through it. It's very important, I believe. This is basically like a Q&A. They say most frequently asked questions. So I'm just going to take on the questions and their answers. 1, if I lawfully possessed a Connecticut other in its original configuration as of 1/31/2023, am I now in violation of the Connecticut assault weapons ban? Answer, no. While the federal rule amended definition of rifle in such a way as to render a so-called other as a rifle under federal law, the Connecticut definition of rifle has not been amended. Therefore, anyone who lawfully possesses an other in its original configuration is not deemed to be in possession of an assault weapon in Connecticut. Now, that's very important. In its original configuration, you are not in violation of Connecticut law, but if you have an arm brace on it, you are in violation of the ATF ruling. Anyone in possession of an other firearm should review ATF guidance, passing the buck, with regard to their status under federal law. However, to determine if they are in possession of a firearm that is subject to NFA Act or rules, SLFU encourages those in possession of others with a barrel length under 16 inches to examine whether their firearm is now classified as a short barrel rifle under federal law. According to the ATF, in their webinar, removing the arm brace does not make you, it completely exempts you from their ruling. It does not make it a short barrel rifle. That's what their wording says. They also eliminated the surface area wording in their initial document, saying that if the buffer tube is essential to the function of the firearm, then you can keep the buffer tube on. So AR platforms need a buffer tube. You're safe. In addition, SLFU is working with ATF on a method that would allow a legally possessed Connecticut other to be registered as a short barrel rifle. I'm not sure what that means. We're going to have to wait and see exactly what that's all about. Now, just realizing that if you do a Form 1 on your other and turn it into a short barrel rifle, just realize you have to carry the Form 1 around with you all the time, and you can't cross state lines without notifying the ATF 30 days prior, if I'm not mistaken. Somebody correct me on that. I'm pretty sure that's how it works. 2, if I sell firearms, when is the last day I can sell Connecticut others? Answer, the ATF final rule applies to semi-automatic firearms with stabilizing braces only, which means that others without the brace should be good both for the ATF and the state of Connecticut. Dealers should consult ATF guidance, passing the buck, regarding the legality of firearms equipped with stabilizing braces on firearms that are now subject to the NFA under federal law by virtue of the ATF final ruling on stabilizing braces. If the federal government has determined that these firearms are short barrel rifles, they will require registration under federal law. Pursuant to state law, or other firearms are not prohibited at this time. 3. How does the ATF final ruling on stabilizing braces affect an FFL selling what are deemed Connecticut others to eligible persons in Connecticut? The ATF final rule does not affect the sale of other or CT other firearms by an FFL. Good news. Presently, it is not unlawful under state law for an FFL to sell such firearms. However, notice how they say presently? Pay attention. However, if by virtue of the ATF final rule said other firearm is now classified as an SBR under federal law, it is unlawful to sell such firearm pursuant to federal law without following the relevant procedures under the National Firearms Act. If it's designated an other firearm, does not have a stabilizing brace on it, there should be no issue whatsoever. But 4, ATF didn't change the definition of shotguns. How does that affect firearms with stabilizing braces that are semi-automatic with a detachable magazine and smoothbore? The barrel features indicative of a shotgun. Example given, Kalashnikov Comrade 12 gauge, other or similar firearm. Answer, the ATF rule change does not make any substantiative change to Connecticut state law. See FAQ 1. If such a semi-automatic shotgun was classified as an assault weapon under state law, which the Comrade is not, prior to the federal rule change, it remains subject to the existing prohibition on assault weapon under state law. For purposes of state law, the definition of pistol, rifle, or shotgun has not changed. If the ATF rule change results in such firearm becoming an NFA firearm under federal law, anyone in possession of such firearm should review ATF guidance referenced above, passing the buck. If the firearm has not been evaluated by the ATF's Firearm Technology Industry Services Branch for firearm classification, then we cannot offer any guidance of its legality federally. Comrade 12 should be fine then, because in their when they initially put out a draft for the stabilizing brace, they said a rifled barrel. Comrade 12 or a shotgun in that configuration does not have a rifled barrel. So technically, Comrade should not have any issue with the state or the feds. 5. How does the ATF final ruling on stabilizing braces affect individuals processing CT others regardless of barrel length in Connecticut? Answer. Generally, the ATF final ruling does not have any effect on Connecticut law at this time. Keep in mind, at this time. This new ruling affects the barrel length and overall length as it pertains to NFA items and the need to obtain a tax stamp at the federal level. Due to the registration period for assault weapons being closed in Connecticut, we are diligently working with the ATF, on what documentation would establish legal possession of an other in order to obtain a tax stamp for any firearm deemed an SBR under federal law. Further guidance will be forthcoming on the process for obtaining the appropriate documentation, if needed, to make an application for an ATF Form 1. 6. Can an FFL purchase a stabilizing brace, CT other, from a person? In other words, is the seller's certificate of possession required? The new ATF final rule has no effect on present Connecticut firearms law. CT other firearms are not illegal by virtue of this federal rule. Under state law, the application of a stabilizing brace to a firearm does not create a rifle at this time. If, however, that firearm is considered a firearm for NFA purposes, the FFL should consult ATF guidance, passing the buck, on the legality of their possession of that firearm. 7. Will there be an open registration period? What should I do with my firearm in the meantime? Answer, as previously indicated, anyone who lawfully possesses a CT other in its original configuration is not deemed to be in possession of assault weapon under Connecticut law, and no registration would be necessary. See FAQ 1. While no new firearm legislation has been passed in Connecticut General Assembly, there have been several past and present proposals related to changes in firearms law. Any statement regarding proposed legislation that has not yet been enacted is speculative and is beyond the purpose of this memo. And there it is. Like I said, it's 3 pages, and that's everything that's in it, other than the intro. Now, as it stands now, just removing the arm brace from your other will make you compliant with feds and compliant with the state of Connecticut. Currently, there are 3 lawsuits I know of, Mock versus Garland being one of them, that is directed at the arm brace rule. What I'm hoping is that we get an injunction and put the 120 days, which I believe expires May 1st. May 1st is when the 120 days is that grace period is going to end. We'll put an injunction on that 120 days so we do nothing until it goes through the courts. I did make a video about others a couple of days ago. Like I said, if you know where people can get others, put it in the description box. It's always good to keep people informed as to what's going on, where they can pick up these items. I personally am going to go try to find a couple of strip lowers myself because, not like I need them, but that's not the point of the matter. But there is this document. Like I said, I will try to get it into the description box so you can read it in its entirety. It's 3 pages. It's very straightforward. They usually kept hearing me say passing the buck because they tend to do that a lot in this document. Hey, well, that's the ATF. Talk to them. We not going to make any speculation. And starting right off by saying this does not constitute legal advice lets you know that, we're not taking responsibility for anything we say in this document. So there it is in its entirety. Let's hope for an injunction on the execution of this ruling, and that will keep us safe for a little bit. And it's going to be interesting to see how this falls in place with the fact that the CCDL Grant versus Lamont, the assault weapons ban lawsuit, how this is all going to come together and play out. My opinion, I think that the Lamont administration is freaking out because they know with this current Supreme Court, they probably already weighed out the fact that they may lose in court, and I think they're just trying to pile on as much stuff as they can to just make this a long and costly legal battle. But that's just my opinion. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'll see you on the next one. Peace.